The next case to come before the court is Michelle Rieg, is that correct?
Rieg, yes.
Et al., the Village of Seville. Each party will have up to 15 minutes to present their argument. If you are the appellant, you may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, please let me know, as I'll try to help you keep track of that time. The arguments are being recorded, so please stand behind the podium, keep your voices up, please introduce yourselves. You should not use the names of children or minors or victims, should that be relevant to your arguments. You can refer to those folks by initials or generic terms. The judges have read your briefs, and we are ready to proceed when you are. Would you like to reserve time?
Yes, Your Honor, I would like to reserve 4 minutes, please.
Very well. You may start when you are ready.
Good morning, may it please the court. My name is Jeff Witchey. I'm here this morning on behalf of the appellants. As you can tell from the briefs, the appellants have consistently challenged this MUOD, which is Mixed Use Overlay District process, and the administrative decision rendered by the Village of Seville Zoning and Planning Commission. We have objected based upon site plan oriented challenges, which basically means the physical layout of the property, and we've challenged that in its entirety, in other words, like all together. We've also challenged separate elements of the site plan. Additionally, and more importantly, we've challenged the use of this property, the proposed use of the land and the proposed use of the building. When we look at the site plan challenge and the layout, we look at the Ohio Supreme Court case of Woods versus Rocky River. And that case is important. What that case, the Supreme Court of Ohio stated, a case is moot when an event occurs which renders it impossible for a court, if it should decide the case in favor of the plaintiff, to grant him any effectual relief whatever. Now, admittedly, the Supreme Court did cite appellate court cases where it talked about commencement of construction. But then look at paragraph 14. What rule did they apply? They applied the rule that I just read. They found that inspection reports confirmed the amount of work that had been done. They found that it included pouring concrete for the foundations, the footers, the support columns, the connecting water supply. And then they held it is too late to prevent construction of the 700 Lake project altogether. Therefore, a writ of this court commanding the board to hear the Woods appeals would not grant the Woods any effectual relief. Any effectual relief. That is the basis of the ruling. That is what the law is in Ohio. And so found this court in the Meyerson case. That's Meyerson versus Fairlawn. In that case, the appellant argued that Chafin versus Chafin case, which is a U.S. Supreme Court case, which equals the Woods versus Rocky River case. It's the same standard. Is there relief that's still effectual, relief still possible? Where there's some relief that's possible, the case is not moot yet.
Counsel, so I understand, you know, in those previous cases, as you indicate in the briefs and so forth, that those were 2 different appeals.
In the Meyerson case, they came one originated from a conditionally permitted use, the other originated from a site plan review.
And this is just one here.
In Seville, it's all wrapped into one.
Okay, so I guess my question, I think I understand your argument and I'll read the briefs, but I guess my question is, are you saying that we can parse it out then? That in other words, the court may not have the ability or the jurisdiction to say, oh, remove all the buildings that you've built so far, but we can still say you need to add this or you need to add that, or they didn't take into consideration that there are still some things that are live, so to speak.
The court can look at it in terms of the entirety of the development. The court can also look at it in terms of individual elements of the plan that have been objected to. When it comes to use, that's a challenge that in Highland Square and in Meyerson, this court found is never moved. And that's the biggest problem that we have here, because their proposed use for this land is the exact proposed use that this MUOD statute seeks to prevent. The violations are numerous, varied, and flagrant. There's hardly a provision in the mixed-use overlay district that they actually comply with.
Well, that's where I'm getting confused then, because I want to make sure I understand. Because in Meyerson, once the hospital was built, we said it's moot. The only things that were left were landscaping, were different elements that maybe would impact the use of the property for the neighboring community. So I guess that's where I'm trying to figure out, because that was an argument about use, that the hospital was not something that, should be in that community, that it was a use factor, but we said that was moot.
Because, procedurally, what you held is that use is a challenge to use never becomes moot. What you did in the Meyerson case is went back and looked at the decision of the trial court, who found that it wasn't moot and actually rendered a decision on the merits. And what you found in Meyerson is she made the correct decision on the merits. But mootness it did not apply in either way. The way I like to look at it, and this adds clarity for me, is metaphorically, this mixed-use overlay district is in essence like a cloud that floats over top of a certain area in a given community like Seville. When Seville enacts that cloud, so to speak, that's a legislative act. But when they actually apply that to land, it's like a landowner reaches up and grabs a provision, like a potential use that is allowed under the floating overlay district. When they pull that down, they can only make it apply to their land if they comply with a whole host of conditions. So it's just like a conditional use permit in just about every way. If it were any closer, the two would be exactly identical. Another thing that I'm sure the court might be concerned about is when is it that a developer would have the ability to know that they can go forward, because use is always challengeable. Think about it. If you build a building and you say you're going to put a restaurant in there and it complies with the zoning, you can't change it into an adult bookstore. So that use is always going to be something that's challengeable. And one thing that we need to look at, though, is the procedure that occurs here. The procedure is, first of all, the only people that have standing to object to these decisions are people that are living right in that very area and are directly affected. If they live across town, they cannot file the 2506 appeal. They don't have standing. They have to be directly affected. Then they have to actually show up at the agency hearing and they have to object. Voice their objections at that time, either they or their attorney. Otherwise, they don't have standing. At that point, then if there is a decision that is against them and they want to appeal it on a 2506 appeal, they got to go to the trial court and they have to prove that the agency abused its discretion. Then from there, if they lose at the trial court, then they have to come to this court. And again, they have to prove now that the trial court abused its discretion in finding that the agency abused its discretion. This is not very likely to happen at all. If there is reliable evidence that's been presented, if there's a good faith attempt to meet the statute, it's almost never is there going to be a circumstance where it's going to be where the case is going to be overturned, or where that decision is going to be overturned. But with all due respect to my opponents, Seville and NEO, there was no good faith the effort to meet the statute here. Which is why, as I stand here today, that land is still fallow. There's been nothing done to that land that indelibly impresses it with this project, or that somehow commits it to this project such that any of our relief is not, or that any of our relief would be impossible. In fact, all of our relief, as I stand here today, is still possible. This case is in no way moot.
So what's in the record that shows us what's been done construction-wise?
There are affidavits in the record. We did not get a chance to present anything because the case got dismissed. In the record at the agency level, we filed we showed up at all the hearings. They only gave us 3 minutes to speak, so I prepared an opposition statement. And in that opposition statement, I go through, I think, every single condition and show how their plan is completely violative of those conditions. When you think about a mixed use, the analysis is even more about use than it is with conditional use. Because if you look at if you look at the statutes, you look at the criteria, you look at the conditions, and every one of them, even the ones that relate to like the physical layout of the property, even those are all about making sure these uses coexist, that they overlap, that they meld together. There's restrictions that say they don't want monolithic buildings, they don't want large expanses. You're supposed to submit elevation drawings so you can see how things break up. There's one provision says like you can't go more than 20 feet without changing a roof line. They talk about streetways and things like that. They didn't even submit elevation drawings. There's no attempt to make a good faith effort to comply with this statute at all.
And you're about to go into your rebuttal time.
I will then take a seat for a moment. Thank you.
And I know that there are two appellees here being represented, and you have divided up your time amongst yourselves.
Yes, I'll be speaking for 10 minutes.
Okay, very well.
May it please the court, my name is Chris Ingram. I represent the intervening appellee, NEO Commerce Center, LLC. And we'll just start by, first of all, clarifying that the appeal before this court is very narrow. And in fact, the court need look only to the appellant's notice of appeal, demonstrating that they're appealing the Planning Commission's approval of a final site plan. That's it. And under the case law through both the Supreme Court of Ohio and this court, whenever a case involves either a development plan or a site plan review, the standard of whether or not the matter becomes moot is upon commencement of construction, not upon the completion of construction. The cases that the appellants have pointed out where there is some other standard, those, if you notice, all pertain to conditional use permits. This case does not involve a conditional use permit. The zoning code is abundantly clear that warehousing and accompanying administrative offices are expressly permitted as of right. Whether or not a warehouse goes into buildings to be built cannot be legitimately disputed because it is an expressly permitted use. Furthermore, the zoning code has both expressly permitted uses on the one hand, as well as conditional uses on the other. And there is a conditional use process in the village of Seville that is not necessary here and was not in any way, it's not even relevant.
So what's in the trial court's record about what construction was done?
I would direct Judge Lanzinger the court's attention to Exhibit 4 to our motion to dismiss, which was the affidavit of Mr. Eric Watts, and there were photographs of the construction activity as of the time when we filed the motion to dismiss, and that level of construction activity was substantial, and the court will be able to see from the photographs alone and from Mr. Watts's sworn affidavit that dozens upon dozens of trees were felled, excavated, and removed from the site. They can't go back. You can't return back to the status quo there. The existing structures on the site were completely removed. All the materials were removed from the site. The power was installed, and the construction pad was created, and earthwork commenced, and site grading also started. One thing about this site, if you go there, it's at State Route 3 and Interstate 76. It is not flat. So portions of where the paths will need to ultimately go had to be cleared and flattened. Additionally, NEO incurred more than $2.6 million of expenses at the time the motion was filed. And I know an affidavit was filed in connection with the appellant's reply brief, and would only add that, to date, stormwater basin, since this matter has been on appeal, the stormwater basins have been installed on the site. There are significant reinforced concrete pipes for the stormwater or storm sewer systems that have been brought on the site. And one of the big issues with construction these days are materials. One of the big bottlenecks for this particular project was an incredibly long lead time for the electrical panels, which those have been procured and now are enabled so that construction can proceed.
Counselor,
Oh, I'm sorry. Go ahead, go ahead.
has there ever been a motion to stay or an injunction, motion for injunction filed by the appellant, ever?
No, there is not, Your Honor. And that's just it. The proposed solution that the appellants are urging the court for now is just not workable when you're talking about site plans and development plans. In other words, what they're urging the court to adopt is this piece-by-piece kind of scheme, whereby if a challenger wants to challenge, for say, the walls, we heard that the concerns about the length of these walls. Okay, well, they file their appeal. Now all of a sudden you have the developer come in and say, well, walls are done. So before the court has issued it, that piece of the project is moot. Well, the challengers are also challenging the roof. Well, the roof is done, and so you can see how you're going to end up having many trials on each and every aspect during the pendency of appeals. That's just not workable. That's not practical. Hence, the commencement of construction standard makes absolute sense, particularly where challengers need only seek a stay or seek an injunction, which was not done here.
But isn't the flip side of that is that the appellant would never get an appeal on the merits if you hurry to construction? Or if one little part of the construction, like grading, is done, then it's suddenly moved.
We respectfully disagree because the challenger or the appellant need only seek a stay of execution either at the administrative level below or an injunction when they file their appeal.
So that would solve the whole issue, for your saying.
Exactly, and that's the way it works. And so practically speaking, this is a perfectly reasonable doctrine that both this court and the Supreme Court have followed. And if I agree that the Meyerson case is very helpful in distinguishing the issues with respect to a final site plan as opposed to challenges to the use. This case is about a site plan. And this court recognized that upon the commencement of construction in Meyerson, the appeal of the site plan was moot. This case does not involve a conditional use or conditional use permit. Therefore, there is no outstanding issues to remedy.
So your response to appellant's argument that this was all done together, that it was not done together because there was a separate procedure for a conditional use permit?
Correct.
you're saying that it didn't need one, but I'm just trying to figure this out. Because in Myerson, there were the issues of not being able to obtain an injunction. And we still looked at some of the other issues in the case that were not basically mooted out. And I keep using the word moot, but in other words, that they're still fixable and could be done in order to help the neighboring residents in the use of the property.
And the distinction here, Your Honor, is that no injunction was sought, number one. And number two, this warehouse and accompanying office use is expressly permitted. So the moment that this property was rezoned and the mixed-use overlay district was applied to this property by the village council, that was the opportunity for the residents to, number one, petition their council and object to the placement of this overlay district, or to object to the permitted uses that would be possible for this particular property. They didn't do so. And then finally, they could exercise their right at the ballot box for their elected officials to hold them accountable for that decision. And at this time, and pending any further questions, I will yield my time to Council of the Village of Seville.
Very well. Sir, we're going to hear from the other
I'm
applicant
sorry.
first. That's okay. You will have 6 minutes and 14 seconds.
All right, thank you. All right, may it please the court, my name is Tanya Rogers, and I have the privilege of being here on behalf of the Village of Seville. At the outset, we adopt and incorporate all arguments advanced by our co-appellee in Commerce by way of briefing as well as in his oral argument. We agree that this issue is entirely moot because the matter is confined to a ministerial review of a site plan. And the well-established settled law in Ohio is that once construction commences, in the absence of a stay of execution or an injunction, the case becomes moot, and that's exactly what happened here. The appellants in this case had numerous opportunities to try to pursue an injunction or a stay or a referendum, and did not pursue any of them. There could have been an option. We don't know what the court would or would not have done if that had been pursued. All we know is that it was not pursued, and therefore construction commenced. There's also been some discussion that this mixed-use overlay district is the entire district comparable to a conditional use permit, and that is just simply not correct. The mixed-use overlay district is a distinct zoning district. That area was rezoned to mixed use in 2019. Again, as my colleague indicated, under that mixed-use district, which is set forth in section 611, there are expressly permitted uses. All of those uses are eligible once that property was rezoned. And again, there was an option for referendum at that time that simply was not pursued. If the legislature of the village had wanted all of it to be treated as conditionally permitted use, it could have done so, but it specifically delineated conditional uses and expressly permitted uses. The only unique feature of the mixed-use district, which again should be treated just exactly like any other district, is that it actually requires 2 uses. Now, most other districts are limited to 1 use and an additional approval for any use above and beyond that. That's not the case here. It's otherwise the same process for any other type of permit. The other unique feature here is that a site plan review has to be reviewed as a ministerial function of the Planning Commission and then also approved by council, and that was done here. And that actually raises another jurisdictional defect. I appreciate that this was not briefed. We did not have the opportunity to brief it before the trial court. And again, this review was limited to a mootness issue, but there is a second jurisdictional defect in that this is a ministerial review only. There is no requirement anywhere in the Planning Commission or in the zoning code that the Planning Commission conduct an evidentiary hearing. There was no opportunity for the appellants in this case to present evidence, and the reason for that is because this was not an evidentiary hearing. As they indicated, they were given only 3 minutes to speak. That's because this was a traditional public meeting. And again, after the site plan was approved, it then had to go on and be approved by council, which was done in January. Once again, there was no referendum done of that decision. And that again goes on to show that there is no dispute here of the use. These are 2 permitted uses. The code sets forth in section 61101, which is kind of the outline of what the intent is for the zoning district. That's the same in every other district in the zoning code. There's always a first of, all these aspirational goals for the district as a whole. The second section of 61102 outlines the procedure. The last subparagraph of 611 is G, which says that this has only become final once it's approved by Planning Commission and Council. There then goes on to expressly permitted uses and then conditionally permitted uses. Here, the minimum requirements are 2 permitted uses and then certain development standards. Here, the plan complied with all of them, and so there can be no dispute that they are challenging a use here. The review here, to the extent it is subject to 2506 appeal, is limited only to review of the site plan. And that in failing to obtain a stay, or actually even trying to obtain a stay or an injunction, they ran the risk of this case being rendered moot, which is exactly what happened. We adopt and incorporate the arguments that neither Rocky River nor Meyerson altered the well-settled precedent in Ohio that once construction commences on a case where there's an administrative appeal pending, it renders the entire thing moot. In those cases, they happen to be complete by the time there were arguments, but that does not mean, there's nothing in the actual opinion that says it had to be fully complete and irreversible entirely before it would render it moot. Additionally, we also maintain the objection to consideration of additional evidence beyond what was considered at the trial court level. We would argue that you essentially cannot unring a bell. The court evaluated the evidence that was before it, which consisted of affidavits showing that construction commenced. And we would argue that they cannot show additional evidence later on that the trial court did not have the opportunity to review to show that it was somehow unmooted, if you will, for lack of a better word. So if the court does not have any additional
Let me
questions.
just ask you about
Sure.
that. Well, actually, I have a couple questions. Can you talk to us a little bit again about the offices with this warehouse?
Yes, so in the June 27, 2022 minutes, the preliminary site plan was presented, and at that time, there were 3 large buildings. Building 3 was to comprise a warehouse as well as office space. That was presented in June. It was considered by the Planning Commission at that time and deemed to comply with the 2 requirements for 2 separate permitted uses. And then the site plan is in the record as well.
And finally, in regard to your last argument about unmooting it, the court is allowed to consider additional evidence in regard to mootness, so that would require us looking at whatever may impact mootness, wouldn't it?
Well, we would argue that a court can lose jurisdiction due to mootness, but they cannot regain jurisdiction by somehow it being unmooted. We would argue that it's not the inverse, it's not the same. You can lose jurisdiction, but it cannot be reinstated. All right, thank you.
Council, you'll have 4 minutes for your,
Yes. In terms of the actual construction out on the project, we have submitted an affidavit from Scott Wangler. He is an engineer with the city of Parma. And that the construction out there was, I believe, misrepresented here because there was no sewer lines that have been installed. There's sewer pipe that has been brought to the property, but that's it. The expenses on the property, the engineering costs, permit costs, things like that, that is not, even under a commencement of construction standard, relevant, because it's things that have to happen to the property that indelibly impresses it with a particular project, so that such that other relief cannot be had that would be effectual. The argument that my client should have filed for a referendum is probably the most disingenuous argument that Seville and NEO make. At the time that this property, at the time that the mixed-use overlay district was filed on record, the statute looked different than it does today. Rolling out the red carpet for this developer, they changed the standards that the Planning Commission had to look at these conditions. It used to be that you would have to get a variance. When they saw a height requirement, they went for a variance. But when they realized that their plan was off the range, not even close to what is contemplated in this mixed-use overlay district, they file an ordinance under an emergency hearing so that we couldn't file a referendum. And that said that the planning commission can make any reasonable accommodation or any reasonable waiver that they want to make. And they pretty much waived the entire statute. That is currently before the federal district court on a constitutional basis. Additionally, I'd like to speak about the conditional use permit. They would have the court believe that the prior holdings of this court in Highland Square and Meyerson state something to the effect that it is a conditional use permit exception to mootness. It's not. If you look at the language that you have in your cases, it says that any challenge to the use of the building. So it doesn't have to be a conditionally permitted use finding. It's just a challenge to the use of the building. We have a unique concept here in this overlay district that again, you have to pull this down. Even they call it a permitted use because that's what the statute says. But you could call me Mr. Smith all day long. I'm not Mr. Smith. I'm Mr. Witchy. And when you look in pari materia and look at exactly what this is, it is no different than a conditionally permitted use. But again, your language in these cases is even broader than that. So with that being said, the trial courts, I did want to mention too about the stay. We did not file for a stay because we do not have, my clients do not have the financial wherewithal to post a bond necessary to stop a $63 million project. So that's why we couldn't do it. And that's not one of the elements though for mootness, because if it were, then the only people that could ever bring a 2506 appeal are the very wealthy. So with that being said, the trial court's decision should be reversed. The case should be remanded for the trial court to consider the appellant's objections to the NEO site plan, both with respect to the site plan as a whole and on an element by element basis with respect to the proposed, and I say this in air quotes, mixture of uses.